We are going to Massachusetts in court for the Commonwealth versus Karen Reed. This is after the jury was hung. The defense is arguing that the jurors had come to verdicts on count 1 and 3. And because of those verdicts, the court must dismiss counts 1 and 3. The law is not really on the defense side here, and it is very unlikely that the judge will rule today. I think this is just going to be oral argument, and she'll take it under advisement. If the judge does rule, probably not going to be the way the defense wants, because the law is more squarely on the side of don't ask anything of these jurors and let the appellate court sort it out. So if there is a ruling today, it's probably going to be a blanket denial. I think the defense's Hail Mary is the dismissal. I think what they are really hoping for is to allow affidavits from the jurors or allow them to question the jurors about that. I don't even know if the court will allow that here. Of course, the prosecution could dismiss counts 1 and 2 based on this information, but they don't seem inclined to do that at all. This is the defense motion, so the defense argues first and should have an opportunity to rebut. The prosecution's going to argue. What he closed with is, Your Honor, really, let us talk to the jurors. Let us ask the jurors, because if the jurors came to a verdict, the prosecutor should be standing up here with us saying, we need to hear from the jurors. And then he said, and if the court can rely on the affidavits we have, just go ahead and do this now, which is definitely not going to happen. So let's continue on and listen to Adam Lally and what, if any, argument he's going to make. The prosecution's argument, it is in line with the motions. I've covered all of the written motions here. And he's saying, Your Honor, you can't do this under the law. You can't do this under the rules of ethics. Just because the jurors reached out to the defense doesn't mean they can inquire about the deliberative process. But I think there is room to argue what the deliberative process is and asking, did you reach verdicts? I think there is lots of room to argue that that is inquiring not about the deliberative process, but about the jury results. And so with that, we are going to pop back to the response from the defense. Remember, the defense gets a rebuttal because it is their motion. Your Honor, do justice. That's what he's arguing. You are respected. You are an incredible jurist, and what you have to do is justice. He is appealing to her on a personal level, and you know that it works with humans to say, I trust you. I believe in you. You are ethical. You are so, so smart. Please do the right thing. It works much better than fighting. And that's exactly where he is coming in with a argument, not just appealing to the judge, but appealing to the judge's sense of duty in her office. You're up there wearing the black dress, Your Honor. You took an oath. You have a sacred duty to this community and to this court and to the law as a whole. Thank you. It's a smart argument. She's going to take that under advisement. That's exactly what she's going to do.
Thank you very much. I'll take this under advisement.
Yep, and we're done.
Coach, may I hand the Nicole case to you?
Sure, thank you.
She's like, great, we're done. I heard what you had to say. I did my job. I let you argue. I'm out. Goodbye, everybody. Goodbye, goodbye, goodbye. Get the fuck out. We're done. Thanks, everybody. I'm out. Peace. And she's off. That's it. I told you you'd hear oral argument. Here is your oral argument. Thanks. Okay, bye. At the end of about an hour and 30 minutes of hearing, both sides, the defense and the prosecution, essentially argued what was in their written motions. The defense leaning more into the argument to hear what the jurors have to say, affidavits from the jurors, interviews with the jurors, non-public proceedings where the court can question the jurors, and narrowing those questions down to just, did you reach a verdict on count 1, count 2, count 3 as a jury? That's all. And inquire of them. And then at the end, the defense argued, but of course, if you want to take the word of the jurors we've provided you, go ahead and dismiss it. That's what has to happen. This jury acquitted Karen Reed on counts 1 and 3, and you cannot allow the government to retry her on those counts. It violates double jeopardy. They also started arguing some of this is new evidence. So they're laying the groundwork. This is a motion to dismiss, but I think the judge is laying the groundwork for perhaps a motion for what? New trial? Because she already has a new trial coming up. The judge, of course, did not rule today. I am not surprised. I expected the judge to take this under advisement, and that's what she has done. And then the prosecution argued the same thing. Your Honor, you can't inquire. The rules, the court, the rules of ethics, you can't inquire into the process of the deliberating jury, and this is inquiring into the process. The jury didn't put anything on the verdict forms. The jury had the jury instructions. The jury didn't ask a question about this. The jury did not come to a final verdict, and there's nothing the court can do here under the law. The Commonwealth can retry. The court should not dismiss this case, and the court cannot inquire into the jury questions. And then on the rebuttal, the defense argued, Your Honor, the jury instructions said keep deliberating until you've reached unanimous verdicts on all counts. Maybe the jury just didn't know that they could come back essentially with a split verdict, that they could render verdicts on some. Maybe they thought they had to render verdicts on everything if they were going to render verdicts on anything. And of course, that's not what the law requires or intends. So, Your Honor, we have to inquire. At a minimum, we have to know what these jurors said. And at the end, the court said, anything else from the people? No? Okay, I'll take it under advisement, as she was like gathering her files and getting up and leaving the courtroom. When will the court rule? I do not know. How long will it take her to render a ruling? I do not know. Could the judge give this kind of a two-part ruling saying, at the moment, we need to hear more from the jurors? Could. Absolutely could. I don't think the judge is going to dismiss this outright. I don't even know if the judge can dismiss these counts outright under the case law. I think the action that the court can take under all of the case law is to ask the jurors, either by affidavit or in court. Would that necessarily be a public proceeding? Not necessarily. So could she ask the jurors one by one, did you reach a verdict on count 1, count 2, count 3 as a jury? And then go from there? Yes. I still don't know if there's much of a procedure there for the court to dismiss the counts. But once you have all 12 jurors saying that they reached unanimous verdicts, if the court then denies the motion to dismiss and says, under the law, there's nothing I can do here, which I think under the law, there's not a lot that the judge can do. It puts the defense in a really good position to argue to the appellate court, this is not the result that the Constitution contemplates. This isn't the result that our jurisprudence contemplates. This result is against the Sixth Amendment. This result goes against the concept of double jeopardy, and let the appellate court make the ruling. They're setting themselves up, or trying to be in the best position to make that argument, because if the judge denies it now and it goes to the Court of Appeals, the Court of Appeals is going to be like, I mean, okay, so 4 people said there was a verdict, and like, that's not 12, and it's not on the verdict slip. So what would you like us to do? The defense puts themselves in the best position to continue to argue this if they know what all 12 jurors said. And I think that's why they really leaned into that during their argument, because that is really their best hope. The court is, I will be stunned if the court grants a motion to dismiss. Absolutely stunned. I don't see the court being able to do that. I think it's still an unlikely result that the court allows the jurors to be inquired into, but I think it is the best result for everyone involved to hear what the jurors have to say. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.